Good morning, everyone, and welcome to Lavelle Law's Breakfast Briefs. My name is Jennifer Tee, and I'm a shareholder here at Lavelle Law. Our topic today is using litigation to heal your business and to avoid disaster. We thought this would be a really good topic because this year's been so tough and hard on our businesses. As many of you know, we do these breakfast briefs every quarter, and they range a variety of topics. We always welcome new as well as previous attendees to join us again. Lavelle Law is a full-service law firm. We have offices in both Schaumburg as well as Chicago, and we have attorneys who specialize in almost every facet of the law. And with that, we'll get started here. And if you have a question, feel free to use the Q&A function, or you can also save it to the end. Today, our presenters are Matt Sheahin, myself, and Lance Ziebell. First up is Matt Sheahin. He's a shareholder at Lavelle Law. He's been practicing for almost 25 years. He focuses his practice in litigation, and he also runs and heads up Lavelle Law's litigation department. Matt is going to talk to you today about injunctive relief. Please welcome Matt Sheahin.
Good morning, everyone. Thanks for joining us on this freezing cold morning. Talk about litigation to help your business. Seems kind of counterintuitive at first, but hopefully I can shed some light on that. We do hope to start doing breakfast briefs in person again soon. It's a lot more fun with coffee and snacks and getting to see people's faces, but this will have to suffice for now. So I'm going to be talking about injunctive relief and really what we refer to as preliminary injunctive relief. So let's go to the next slide. So we'll talk about these questions here today. What is preliminary injunctive relief? What is the difference between a TRO and a preliminary injunction? How you can get a TRO without notice and with notice. The bond requirement if you're successful in obtaining an injunction, and basically what you need to prove in order to get a TRO or preliminary injunction, and how you can protect yourself in your contracts with your company with this kind of relief. So many people understand that most lawsuits are about money, right? I mean, most civil lawsuits are about money. If you had a contract with somebody and they breached it and they owe you money and they don't pay, you want to sue them to get that money. This injunctive relief covers what attorneys refer to as non-monetary relief. You are not looking for money in this particular type of motion or action. It's where a civil litigant's asking the court to enter an order directing another party to engage or refrain from engaging in certain conduct. So it is preliminary in nature, in the sense that it does not conclude the case, and nor does it get to the ultimate issue of how much money one party owes another, but it is really focused simply on enjoining certain conduct by an offending party. And I did put in here in this first slide about how you can ask for relief to make another party do something. That's called a mandatory injunction. That is even more difficult to get, as obviously most of the time the court doesn't want to force parties to do something. In most cases, when you're looking for injunctive relief, you're trying to ask the court to stop a party from doing something, restrain them, enjoin them, and that's what we'll focus on today. So a TRO and a preliminary injunction are both of a limited duration. The way to think about it is, if you come in at the beginning of a lawsuit and you want to restrain someone at the beginning, you're probably the first thing you're going to do is file a motion for TRO. That will be ruled simply on the briefs, that just the papers that the attorneys submit. It certainly may have affidavits from witnesses that prove the elements that are required in a TRO, but the court will literally grant or deny a TRO based on the briefs and the arguments from the attorneys. And literally, you can move for a TRO the day after you file a lawsuit of this nature if you bring the motion that quickly. You can move for a TRO with notice that is preferred by the court and by the parties. They do want everyone in the court to be able to address the issues that are in dispute. However, you can move for a TRO without notice in certain circumstances. And also the difference between a TRO and a preliminary injunction, the TRO is truly temporary. It should last about 10 days, 14 days, until the court can have an evidentiary hearing with live witnesses to determine whether that TRO should stay in place. So let's say that you had a salesman working for you for 10 years. You spent a lot of money with that salesperson, building up the client base, sending him or her to various events and connecting them with people in the industry. And they've, of course, have cultivated certain relationships. But if you're keeping, for example, your relationship and the way you get clients confidential, and you're sharing that with them, you can probably protect that salesperson from moving to a competitor and using all the information that you've provided that salesperson against you. You can actually have a contract that prohibits them from using your customer list and or going to a competitor and competing with you for a certain period of time. If they ignore that, you can file a lawsuit against them to stop them from working for that competitor. And the first way you would do it would go for a TRO, which means you want to stop them right away. You want the court to issue an order right after the day or two after you file the suit to make them stop competing. If you win, then the court will set a hearing for a preliminary injunction. And that is essentially like a mini trial. Live witnesses in court, cross-examination, the whole thing you see on TV. And that will determine whether or not that TRO is then, it graduates basically to what we call a preliminary injunction. If you're successful in getting a preliminary injunction, now you have that order from the court that offending party cannot is stopped in their tracks basically for the duration of the lawsuit. So it can be a year, a couple of years where they can't compete. And if they do compete with you and violate the contract, you can actually get sanctions and all sorts of nasty relief against them. If we can move to the next. So this a TRO without notice compared to a TRO with notice. I think, but all litigants in the court prefer a TRO with notice. And again, in any dispute, the court wants to hear the arguments from both sides and make an informed decision. However, you can get a TRO without notice. This is generally, as you can see from the slide, it's disfavored, but you can generally show that the court, if we gave notice to the other side, they would basically abscond with the thing that we're trying to protect. It's like the proverbial plane on the runway with the treasure is about to take off to leave the country. Well, I can't give them notice because they're just going to leave the country. So I have to do it without notice. You'll have to explain to the court why giving notice to the other side would destroy the relief that you're trying to obtain. It's rare to need to go this way, frankly, in my opinion. It will also make it, in most instances, more difficult to get a preliminary injunction depending on the discovery that's going to be done. But there are certain circumstances where just the facts surrounding the dispute make sense to go in without notice. Next slide, please. And then there is a bond requirement. So you may or may not be familiar with the bond in civil cases. Certainly, you've probably heard of it in criminal cases where a criminal defendant must post bond in order to, not go to prison or to be relinquished to the home arrest or something like that. But there is a bond requirement also in various preliminary injunction relief and a TRO, frankly. It really is the cost of getting a TRO or preliminary injunction. Because since the court is making a decision based on less than the full record, there may be, for example, on a TRO, a couple affidavits, some documents that the court is reviewing, and of course the briefs from the defendant, since they literally may have only been notified of the action the night before. Of course, good attorneys will work overnight and try to get a great brief together, but it certainly doesn't give them a chance to put forth the full defense. So there is a real danger that a TRO that's issued may not be correct. So that is why the court will require most petitioners that are granted a TRO or a preliminary injunction to post a bond, which is basically like insurance for the defendant that if they were improperly restrained, that they have a fund of money to go to compensate them for their the improper action that was taken against them. It is not a requirement. It is up to the court's discretion, but that is very likely going to be a fight for the parties if an injunction is granted. So now we're going to get into a little bit more of the legal weeds here, so to speak, but I'll try and keep it at a high level so it makes sense. So you have to show, when you file for injunctive relief, TRO and or preliminary injunction, you have to show various claims. And I just want to go back a few screens. I forgot to mention, you don't have to go for a TRO at the beginning of the case. You could file a complaint with an action for a preliminary injunction and notice it up at a later date. So you don't have to go that route with the TRO right off the bat. In my opinion, though, if you're going to go for a preliminary injunction, you might as well go for a TRO as well. If you get it, you're going to have the court leaning in your direction, and you have, you've already kind of got the court swayed to your position, and I think it's more effective that way. But you don't have to do it that way. In order to get either one, a TRO or a preliminary injunction, you got to prove these factors. So you got to have a protectable right. So, for example, in the type of example I was talking about, where you have a salesperson under an employment contract with a non-compete or a non-solicit in that contract, which my partner Jen T will talk about, or you have trade secrets that you want to protect from your competitors, and that employee had been with your company for a number of years and had access to those trade secrets. That's another topic that will be addressed today in more detail by Lance Ziebell, that you'll have to show the court that you have that right. So obviously, if it's in the contract, you can set forth the contract, you can show that it was executed, you can affidavit from one of the principals that signed it, that this is our contract, this is what we're trying to protect, so the court can determine whether or not that is a protectable right. You also have to show, you don't have to prove that you're going to win the whole case, because it is not what attorneys call a trial on the merits. That would be the full-blown trial at the end of the case. After all the discovery is completed, depositions were taken, experts were done. But you do, to get a preliminary injunction, you have to show them that you have a likelihood of success. You have to show the court enough that, look at the proof that I have here, Your Honor. And although I don't have to prove every single element of my claim now, you have to show the court that it looks like you will succeed on the merits down the line. So it's not the same kind of burden, but it is a burden nonetheless that you have to meet. You also have to show irreparable harm. And these next two categories is frequently where the fight is found in litigation. Irreparable harm means that you can't if it doesn't stop now, the damage to your company will be, very difficult to calculate, and it'll be very difficult for you to recover from. It's difficult to, for example, if a salesperson goes somewhere and snatches half your clients by contacting them and moving them over to a competitor, as you can imagine, it'd be difficult to quantify how much that hurt your company in terms of exact dollars. You've lost standing in the industry. You've lost, obviously, the revenue from those clients. You've lost those relationships. So all of that factors into what I would argue is it forms the basis of irreparable harm. You also have to show that there's no adequate remedy at law, which means money is not going to compensate us here. Of course, every case is about money. So the court is very used to hearing arguments from defendants that, hey, judge, yeah, something may have happened here, but money will compensate. But that is not always a winning argument for the defense. Of course, there is a money component, but if it's, as for my example about irreparable harm, if it's going to be difficult to calculate the exact amount of damages as a result of the offending party's conduct, for example, if they stole if you're in an IT space where you have a special code that is valuable on the market, and your employee takes that coding and gives it to a competitor, that's going to be very difficult to break down into how much in dollars that hurts you. Moreover, in the example of a salesperson that went and took your client list and is moving your clients over to a competitor, that is a transgression, an offense that's happening every day. Every day he's trying to siphon clients away from you. So that is what we call it's like a continuous nature of damage. That is also very difficult to calculate what the monetary remedy is going to be. So you have to show all four of those things in order to get a TRO or a preliminary injunction. It is what we call kind of extraordinary relief. It is not the normal type of relief, which is money, but it's not impossible to get. We've handled many cases on both sides for plaintiffs and defendants at Lavelle Law, and we've been successful in obtaining injunctions, and we've been successful at defending them. We've also had cases where we were defending one and the court granted an injunction, but didn't give the other side all the relief that they wanted, or as many clients protected as they thought should be protected. So there's a lot of different avenues to fight on. The way that this helps your business, I think, is if you have someone that's doing this kind of offensive conduct, contrary to your employment contract, contrary to your agreements, or contrary to the trade secrets that you've developed, and you bring a TRO or a preliminary injunction and you win, and you get it, it really sends a message to the rest of your staff and the people within your company that you don't tolerate this kind of conduct within your company. And if someone tries to violate your contract, you're gonna do something about it in the courts. It also sends a message to your competitors in the industry that you're not gonna lie down and take this kind of abuse sitting down. You're gonna get up and fight, and you're gonna protect your rights. So those two factors, both within your company and within the industry looking at your company, should all be considered in whether or not you want to pursue this type of remedy. And that kind of reputation, both within your company and within the industry, is just extremely valuable and hard to calculate. And this is something where the sort of litigation to protect your rights can really have a lasting impact on your company beyond just the TRO and beyond that particular employee or competitor, but within your reputation and your space within the industry as you move forward. We go to the next. So this is kind of getting a little bit more into those factors I just discussed. Again, the big thing with protectable right and likelihood of success on the merits, again, you don't have to prove your entire case. You have to show that there's a fair question of the existence of this right, that there's a fair question that you'll win the case on the merits. So the court doesn't ultimately decide contested issues of fact, but they do look at the evidence and they do make judgments as to whether or not it looks like there's a protectable right there, whether or not it appears that the moving party is going to succeed on the merits. But again, that the way that the court and the attorneys think about it is this concept of a fair question. So it's a lower burden, but it is a burden nonetheless for the plaintiff to carry at these hearings and at those arguments. There's the irreparable harm that we just talked about, harm that cannot be prevented or fully rectified by the final judgment after trial. So it's this, again, harm that money is not going to be able to compensate. This blends into the no adequate remedy at law as well. Like I said, there's almost always some money component of the case. But if money damages are going to fail to make the plaintiff whole, or again, as we talked about, those transgressions, those offenses are of a continuing character, and if the court doesn't step in to stop it, there is no adequate remedy at law. That's how the court will look at it. Many times we advise our clients if we're drafting employment agreements or vendor agreements or any kind of joint venture agreement, we want to put in some clauses, some provisions within the contract that address adjunctive relief. We want to address jurisdiction, about what court the parties will need to fight in. We want to address what state's law applies. Obviously, if you're here in Illinois, we would write that if Illinois courts would have jurisdiction, Illinois law would apply. But you can also put in clauses that say, you know, if there's a violation of these particular provisions, that injunctive relief, that the other party agrees that injunctive relief is proper and that they're not going to contest some of those elements. You can put that in your contract. It will be helpful at court for you to point that out, but it will not alleviate or eliminate your obligation to prove those four elements. It will be one of those factors that the court will look at. It is helpful. It's better to have it than not have it, but it is not your ace in the hole, and it is not going to win you the whole shooting match as far as the preliminary injunction and TRO is concerned. So that's my brief, very fast primer on preliminary injunctions and TROs. It's a pretty exciting part of our practice. We always enjoy it because of the emergency relief and the urgency that our clients have. And if this is something that comes up in your business, we'd certainly be happy to talk to you about it. Obviously, in these situations where it is emergent, you cannot sit back. You have to talk to your attorneys as soon as possible to determine what can be done and how quickly it can be done. I think there was a question, Lance, did you see anything there? Or I guess it was taken away. Okay, that's my presentation for now, and I'll pass it on.
Thank you so much, Matt. It was really informative. Next, I'm going to talk about employment agreements. And the main topics I'm going to talk about is what is employment at will, what are the general provisions in employment agreements. Sometimes there's also restrictive covenants, so I'm going to discuss those. And then I'm also going to go over some provisions that cannot be included in employment agreements. So first, what is employment, quote, at will? This is just a general rule all across America. It's employment at will. What does that really mean? At any time, either the employee or the employer can decide to end the relationship for any reason whatsoever, so long as it's not for improper purposes like discrimination. Neither the employee or the employer are forced to stay in the employment relationship. What are the types of provisions that could be in employment agreements? The first would be the employee's duties. What is their title? What's the type of work that they're going to be performing? What are their duties generally? Next, you would have compensation. That could include general compensation. It could include bonuses. Could include other compensation. That would all be listed in the employment agreement. Also, there could be a remedies section. In the event that one party breaches the agreement, the employment agreement might state that the party who breached may be liable for injunctive relief, which Matt just discussed, or it could be money damages, which is exactly like it sounds. You'd file a lawsuit for money, seeking damages in the form of money, or you could do all of them at once. You're typically not limited in your employment agreement from pursuing all of your legal remedies. There could also be a provision as to attorney's fees and costs. This would also be a scenario where if one party breached the agreement, then the other party or the winning party in the litigation may be entitled to their attorney's fees and costs. Another type of provision is choice of law or venue. You can actually choose what law you are going to follow and what law is going to govern your agreement. So if your business is in Illinois, you may choose Illinois as being the law that is going to govern the terms of your agreement. You can similarly choose where you're going to litigate it. You can put in there the venue that you want to litigate your cases. You can go so far as to put Cook County. All of the cases related to that employment agreement or breach of that employment agreement would have to be filed in Cook County. Now we're going to get into restrictive covenants. These are sometimes in employment agreements. They're not always in an employment agreement. but this is many times the way that an employer can protect themselves. The three different types or general types of restrictive covenants are non-competes, non-solicits, and confidentiality or trade secrets. So the first is non-compete. So generally, Illinois courts disfavor non-competes because they are really a restraint on trade. Essentially what you're saying to your employee is you can't work in a certain field for a certain duration of time after your employment. So because that's a restraint on trade, they have to be carefully crafted in order to make sure that they're enforceable. An example of when you might use a non-compete is, let's say you have an employee who immediately left your employ and went to a direct competitor and then took all of the information that they gleaned from your business and brought it over to the competitor. That would be a perfect scenario where you would want a non-compete in order to protect your business and keep your clients in-house and not have an employee going out and sharing essentially all of your practices with your competitor. Okay, so how can we make sure that that non-compete is enforceable? So there's certain requirements. It has to be reasonable in scope, reasonable in duration or time, and reasonable in geographic area. So if you limit the non-compete to a reasonable time frame within which the employee cannot get a job that directly competes with your business, and also it's also limited to a geographic area as opposed to worldwide or various states, you're going to have a better chance of having your non-compete be deemed reasonable and therefore enforceable. Typically 1 year is considered reasonable by Illinois courts. Another factor that businesses need to show is that their customer relationships are near permanent and the employee only contacted or knew those customers by virtue of them actually being employed by you as the business owner. Also, employers must show a legitimate protectable interest for the non-compete provision. Now, the next restrictive covenant is non-solicitation. And there's two types of non-solicitations. One is non-solicitation of the employer's clients, and the second one is non-solicitation of the employer's employees. So Illinois courts enforce non-solicitation agreements if the terms are reasonable and necessary to protect the employer's legitimate business interests. Courts generally do not enforce provisions that prevent the former employees from soliciting customers with whom the employee never had actual or direct contact, however. And then the third type of restrictive covenant is trade secrets, which Lance is going to go into depth into, so I will not. But essentially, these provisions restrict an employee from disclosing certain information during and after the employment that they gleaned during the employment. Okay, and what types of provisions cannot be included in employment agreements? You can't prevent an employee from making truthful statements about unlawful discrimination, harassment, or retaliation. You can't require the employee to arbitrate claims as to unlawful discrimination, harassment, or retaliation. And you can't have the employee waive or otherwise diminish any current or future claims, rights, or benefits which also relate to that unlawful discrimination, harassment, or retaliation. And with that, that concludes my section. And next up is Lance Ziebell. He is also a shareholder at Lavelle Law. He's been practicing for 12 years. He focuses his practice in litigation, and he's going to talk to you about trade secrets. Please welcome Lance.
Good morning. So some of the things I'm going to talk about encompass a little bit about what Matt and Jen have talked about. But the main things I want to go over: what's a trade secret under Illinois law? Misappropriation of trade secrets, which is the second big section of trade secrets. Actual or threatened use, which is where you generally run into third-party misappropriation of trade secrets, and then potential remedies for trade secret violations. Next slide, please. So what is a trade secret under Illinois law? There is a statute in Illinois that covers trade secrets. It's called the Illinois Trade Secrets Act. It's specific to Illinois. There is a federal trade secret law, which we're not going to talk about today. Most states have some variation of a trade secret statute, but since it is a statute, it's helpful to know the exact definition. So in Illinois, a trade secret is information, including but not limited to technical or non-technical data, formula, pattern, compilation, program, device, method, technique, drawing, process, financial data, or list of actual or potential customers or suppliers that, number one, is sufficiently secret to derive economic value, whether it's real or potential, from not being generally known to other persons who can obtain economic value from its disclosure or use, and is a subject of efforts that are reasonable under the circumstances to maintain its secrecy or confidentiality. So, next slide, please. So there's three kind of things that I'm looking for when somebody asks me if information they have is a trade secret. So number one, is it sufficiently secret? Inner industry knowledge is not always secret all the time. So if you're working in a specific kind of industry, your processes, your ways of doing things, your clients might not be secret because everybody's going to have kind of a general idea of who these people are. The owner has to derive value from its secrecy. In other words, good example, here's a customer list. If you have a specific customer list and you don't want anybody else to know it and you get profit from that, that's the value from its secrecy. And then the owner has to maintain reasonable steps to keep it secret. So in other words, something's not protected if you're exposing it in the public. If somebody that knew nothing about what you do created a customer list or a product by independent invention, accidental disclosure, or reverse engineering. Reverse engineering is one that surprises people. You are allowed to reverse engineer products. There's probably a litany of layers to that, but as a general practice, if somebody sees something and is able to create it, reversing the process, that's not going to be a trade secret violation. So essentially what the courts look at when they're evaluating a trade secret, and Matt and I have litigated this a few times, so we're familiar with this. The test that they're looking at is, number one, the extent to which the information is known outside the owner's business. So again, if something is common knowledge outside of somebody's business, it's not going to be extended trade secret protection. The extent to which it's known by employees and others involved in owner's business. If everybody in a particular operation knows everything about the operation, you may not have a trade secret at that point. The extent of measures to safeguard the secrecy. We'll talk a little bit about this, but if you have no measures in place, then it's pretty likely you don't have a trade secret. On the other hand, if you have a litany of measures in place, that would indicate to the court that it's something that you are trying to protect. The value of the information to competitors. Obviously, if competitors would gain an advantage over you, example again, customer list, by having your customer list, that has value to the competitors. The amount of effort or money expended in developing the information. If you go to the phone book and just compile a list, you probably didn't put much effort or money into that. If you, over many, many years, cultivated a list of clients and had all kinds of information, and were taking out these clients and wining and dining them to get that business, that would indicate to the court the amount of effort or money expended to get the information. And then 6 is the ease or difficulty by which information could be properly acquired or duplicated by others. Again, if your list comes from the phone book and I can go in the phone book and get that same list, it's not really hard to obtain that information. There are some things, even if you just look at the trade secret definition, that are generally considered a trade secret. Customer list is one of them, but there's some things that the courts will again look at. How available is this list? If you're buying a list from a company that sells that list to 50 other companies, that's a pretty publicly available list. Again, and the cost of compilation is also critical. If you paid $1 million for that list, then it might have some more value than it might in other circumstances. The size and the nature of the business, smaller specialized businesses have a harder time establishing trade secrets. That might seem a little counterintuitive just because if you're a smaller specialized business, you might have a specialized product, but you also probably have a pretty limited customer list, meaning there's only so many companies you sell to. If your competitors are in that same field, they probably all know those same companies. The nature of goods sold, again, that kind of goes back to the size and nature of the business, but a very common product as opposed to something specialized are going to have different factors. The size and content of the list is a factor. If you have a list of names and addresses, that's not a lot of information. If you have names, addresses, phone numbers, contact names, history of orders, that's the kind of information that's more likely to be protected. And then another thing the court will look at is the previous relationship that you have with that customer and how long that relationship has gone on. As Jen alluded to, then your permanent relationship status is going to be a factor there. Some other things that are generally considered trade secrets, pricing information can be. What you charge generally is not a trade secret. However, if you have a specific formula for generating a profit margin or how you arrive at that price, that could be a trade secret. Computer programs, they can be a trade secret. It really breaks down a lot of times to how unique the software is. Product drawings can be trade secrets. Product formulas, Coca-Cola's formula is a trade secret. And then number 6 here is one of the things that frequently litigated in court, and it's expertise versus employees' general skill and knowledge. There are certain things that employees learn while they're an employee that they can take with them. You can't stop a person, as Jen alluded to, from competing or having a job. So their general skill and knowledge they're allowed to take with them. What they can't take are trade secrets or confidential information. And I'll circle back to that and kind of talk about where that comes into play. So what do you have to do to maintain secrecy? The steps have to be reasonable, but not perfect, meaning you don't have to do every possible thing under the sun to protect a trade secret. Now, there are some things that they will look at to say you're not doing adequately, and that's number 2. If you do have confidentiality agreements or confidentiality provisions in employment agreements, and you don't enforce those provisions, that may seem to indicate to the court that you're not actually taking reasonable steps to protect the trade secret. Another thing the courts will look at is the size and resources of the trade secret's owner. Smaller businesses with limited budgets aren't necessarily expected to undertake these huge secrecy projects. Whereas if you're IBM, somebody bigger, you might have a different standard of what you really need to do to make sure something is being protected. And then there are some specific methods, taking precautions in how your information goes to third parties. That could take the form of like a non-disclosure agreement, limiting access, password protected files, or information only available on a need-to-know basis, and then confidentiality labels. Now, number 1 on this list is the employee non-disclosure agreements, confidentiality agreements. Jen talked about the non-compete and non-solicit provisions. Confidentiality provisions are a little bit different, and courts will enforce those. You can define in an agreement, an employment agreement, what you consider confidential information or a trade secret. And it could be everything that, the Trade Secret Act defines: customer list, processes, pricing, all of these different things. And the court will enforce that. They are broader in the sense that they don't necessarily have to be restricted in time. I've seen many confidentiality agreements that run forever, from the day you leave the company start till you pass away. And those will be enforced just because of the nature of the information. So misappropriation is the second big thing that you see in any trade secret litigation. I mean, it's great if you have a trade secret, but it usually only becomes a problem in litigation when somebody steals it. So again, we'll turn to the statutory definition here. Misappropriation is acquisition of a trade secret of a person by another person who knows or has reason to know that the trade secret was acquired by improper means, or disclosure or use of a trade secret of a person without the express or implied consent by another person who used improper means to acquire it. At the time of disclosure, use knew or had reason to know that knowledge of the trade secret was, again, generally, I'm going to say generally acquired improperly to save everybody the pain of reading this. And then the third is also a similar concept of before a material change of position. So what's improper means? Pretty kind of easy. Theft, bribery, misrepresentation, breach or inducement of a breach of a confidential relationship or other duty, or espionage through electronic means, hacking would probably be the easiest one. Specifically, taking, copying, or memorizing. Now, memorizing is the interesting one. Because employees, when they leave, may have worked with a lot of clients, they may have friendships with those people, and they may have relationships with them. And when they leave, those relationships don't just go to the wayside. So there is sometimes a very interesting challenge in court of, talking about whether the information that was taken is a trade secret or whether it's the general knowledge of the employee. Sometimes that just turns on how much information, what that person's relationship was. It really is a case by case thing. Reverse engineering or independent development, again, are not trade secrets. But I do want to turn to the written agreement determining whether conduct's proper or improper. Again, if you have a tightly drafted employment agreement with good confidentiality provisions, that's going to define how that person can or cannot use that information. And as Matt alluded to, that is the one step you immediately have to show you have a right because it's in the contract. Next slide, please. So circumstances that give rise to a duty to maintain secrecy. Again, the employee obtains the information pursuant to a confidentiality agreement. Second, the employee owes a fiduciary duty that can arise in a number of different situations. Under Illinois, all employees owe their employer a fiduciary duty of loyalty. Courts aren't always crazy to enforce that particular one, but it's out there. And then again, if you are working with an outside party, a third party, you could use a non-disclosure agreement to cover your confidential information. One question we commonly get is, a third party liability. Can a new employer be liable for its employees' theft of its old company's trade secrets? And the answer to that is yes. If the new employer has reason to know or believe that the employee misappropriated those trade secrets originally, that's where you could have a potential issue, even though you had really nothing to do with anything. My experience, Matt can probably speak to this as well, is normally when a former company sues its former employee for a trade secret violation or non-solicit or non-compete violation, frequently the new employer is dragged into the litigation as well, because there's just a sense that they're going to have that information and use it. There are two different types of use of trade secrets when they're misappropriated. You have the actual or threatened, actual somebody proving that they actually used the information to obtain an advantage. Threatened is, hasn't been used yet, but it could be. That's where the preliminary injunction, temporary restraining order, that kind of relief is critical. If you have an employee that's just left, and you think he's going to use the information or you suspect that he took it, that's where you would go after some kind of restraining order. Again, as long as you can satisfy the elements Matt talked about, but you would want to stop that information from getting out before it turned into actual use. The inevitable disclosure doctrine is something that, again, deals with third parties. And under the inevitable disclosure doctrine, former employee can be enjoined restraining order, injunction from performing certain post-employment activities, soliciting, using confidential information, if it can be shown that the employee, when doing his new job, will inevitably use or disclose the trade secrets. The important thing to note here is that you could have an employment agreement that has no restrictive covenants, no non-competes, no non-solicits, and the court will essentially create those to prevent the use of a trade secret. However, in Illinois, they only use the inevitable disclosure doctrine when they can show that there was some kind of bad faith. So in other words, you have to make an elevated showing in court for the courts to actually use the inevitable disclosure doctrine. So what are your remedies for a trade secret violation? And they are set out by statute. You can get a temporary restraining order, preliminary injunction along the lines that Matt discussed. You can also get permanent injunctive relief and money damages. The two types of money damages are generally lost profits, meaning if I owned the trade secret, what did I lose because of that theft? Or unjust enrichment means, what did the new person that stole the trade secret gain? So there's two different measures of damages. The more common one is lost profits, but you can go after the unjust enrichment. If the violation is particularly egregious, you can get punitive damages. And as a statutory remedy, it does provide for attorney's fees, which can make litigating these cases quite expensive. And that is all I have on trade secrets.
Thank you so much, Lance. I'm going to pull up this last slide just in case anybody wants to take down our information. Feel free to email any of us or call any of us. But also, we're opening it up now to a Q&A. So if anyone has any questions, please go ahead and use the Q&A function and we'll answer those as best we can.
Yeah, and I also want to mention, Jen, that we can always, anybody attendee or even someone that didn't attend, we can always email them a PDF of our presentation materials, and a video recording of our presentation today will be available on our website. Of course, we know in the sense that many business owners that are watching this may not have some of these issues immediately at hand. They may crop up in a few weeks or a month from now. Hopefully not. Hopefully you can stay dispute-free in your business. That's obviously ideal. So if there is anything that comes up, you can always refer to our website to watch the video, or of course you can call any one of us, me, Jen, or Lance, for a free initial consultation to talk about the situation that you're facing and your alternatives in litigation, and certainly before litigation. We always want to discuss with clients what we can do possibly before we run to court. It truly is the last resort. But certainly if you're in an emergency nature where someone's stealing your clients or stealing your trade secrets, immediate action is probably the only way to go.
Do we have any questions? Do you guys?
I don't.
There are no questions.
Okay.
Pending.
All right. Well, feel free to reach out to us directly, as Matt just said. And thank you guys so much for coming. Stay warm for the rest of the day and have a great day.
Thanks, everybody.
Thank you.